What does an attorney do when the witness is uncooperative and fails to give him the answers that he's looking for, especially an opposing witness? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now let's say this is a medical malpractice trial. An opposing medical expert is on the witness stand, and I'm asking some very simple questions. And the witness is not giving me straight answers. The witness is playing word games. The witness is arguing with me about the definitions of certain words that I'm asking. So now, how do I get this witness, how do I control this witness to give me the answers that I'm looking for? Well, here's the problem when that happens. The problem is that the attorney will typically ask an open-ended question or a question that is not worded very well. And when that happens, the expert, the witness on the stand, doesn't want to give me everything that I'm asking for. Instead, he wants to give me answers that he wants to give to, again, show to the jury that our claim is full of crap and that we have no basis for a case. So every opportunity, this witness is going to turn around and give it to us. He's going to give us little zingers and try and stab us in the back every chance he can get. So how do I, as the attorney who's cross-examining this witness, how do I control him? Well, there are two key ways to do that. The first way is to ask short, leading questions. You see, when I'm cross-examining a witness, I have a key goal and I have a key advantage. And that advantage is that I set the agenda for what we're going to be talking about. I set the tone. I determine the rules and the boundaries by which this witness has to answer questions. Now, in all likelihood, this witness has been on the witness stand before. In all likelihood, this guy has testified before. In all likelihood, he's testified for the defense, for the doctor or the hospital in many, many instances over the course of many years of his career. So it's not the first time he's taking the witness stand. And he knows that when his own attorney, the defense lawyer, questions him, his objective is to explain as much as possible. Because the more he explains, the more the jury gets to know him, the more they begin to trust him and believe him. But now when I get up, I don't want the jury to get more of an opportunity to get to know him and like him and trust him. Instead, I want him to answer my very specific, very short, very direct leading questions. Doctor, isn't it true you graduated from this medical school? Yes. Isn't it true you did not see or examine this patient? Yes. Isn't it true you only reviewed the following records? Yes. So what am I doing here? I'm asking short leading questions that call only for yes or no. Now, there may be some questions that I ask where the doctor says, I don't know, or I can't answer the question the way you asked it. So there are 4 different options that the doctor can answer. That's it. So let me go back with you even one step further. Before I begin to actually question this medical expert, I need to get this doctor to agree to certain promises. I need for him to make me certain promises before I begin questioning him. So now you might be asking, why would a witness, an expert witness, ever agree to make promises to me before I ever begin to ask him questions? Well, here's how you set it up, and here's how he has to make these promises. Doctor, I'm going to be asking you a series of questions. These questions call only for yes or no. Do you agree that if you can answer those questions yes or no, you will do so? Yes. Doctor, I'm going to be asking you these questions, and if I ask a question to which you cannot answer the question, rather than giving me a long-winded answer or explanation, do you promise to tell me you simply cannot answer my question the way I ask it? Do you promise to do that? Now, if he does not agree, then he's going to look like he's unreasonable, and then I'll ask it again. Doctor, I'm going to be asking you a series of questions, and if you cannot answer that question, don't go ahead and tell me why you can't answer the question. Just simply say, I'm sorry, I can't answer the question the way you asked it. Will you agree to that? Yes. Okay, again, if he does not agree, he looks extremely unreasonable. Doctor, I'm going to be asking you a series of questions that if you are unable to answer, or if you do not know the answer, again, don't tell me why you don't know. Simply say, I don't know. Will you agree to do that? Yes. Okay, so now I get the doctor to agree to answer either yes or no. I get him to agree that he's either got to tell me he doesn't know the answer or he can't answer the question without giving me any explanation. So now it is my obligation, my job as the attorney cross-examining this medical expert to ask short, leading, concise questions. If I make the mistake of asking a long-winded question that calls for multiple answers or a long-winded definition or a long-winded explanation, I've done an improper job. So, if I ask short, tight, leading questions, the doctor can only answer one of 4 ways. Either yes or no, or I don't know, or I can't answer the question the way you asked. Now, rather than get into verbal sparring with the doctor if he doesn't know or he can't answer the question I asked, I'm not going to turn around and say, "Hey doctor, why can't you answer my question?" That calls for an open-ended explanation. I don't want to give him that opportunity to explain anything. I have an agenda. I have a goal. I need this doctor to answer certain questions, and I need him to answer them yes or no. Either you agree with my statement or you don't. If you don't agree, fine, I move on to the next question. If you don't know the answer, fine, I'll move on to the next question. If you cannot answer the question I asked, the way I asked it, I will ask it 10, 15, 20 different ways, just in case you still know the answer but are playing word games with me. And so now the jury will get to see that you're playing word games. If I begin cross-examining this witness and I don't get him to make me these promises, what happens is I might have to interrupt the doctor in the middle of his answer. And then his attorney, the defense lawyer, is going to jump up and say, "I object, Judge. The doctor's trying to answer Mr. Oginski's question. Let him finish." And the judge is going to say, "Counsel, you asked the question. Let the doctor finish." And so now I'm stuck there with the doctor trying to answer my question, and now he's going on and on and on and on. The jury's soaking it all up and they're eating it all up. That's not what I want to happen. That's why it is so important to get this doctor, this opposing witness, to agree to answer the questions in that boundary, in that framework. Only then, if he now starts to play word games with me, if he now starts to argue with me, "Doctor, just a few moments ago, you promised you would answer the question yes or no. Isn't that true?" "Yes." "Fine, well, which is it, yes or no?" "Well, I can't answer the question that way." "Okay, doctor, you promised me just a few moments ago that if you could not answer my question the way I asked it, you promised to tell me, 'I'm sorry, I can't answer the question the way you asked it, and now I'll ask a different question.' So which one of the 4 options is it, doctor?" And now I keep going back to the promises that he made. And after the second, the third, the 4th time, the jury gets to see that this doctor is playing games with us, and now he just doesn't want to answer the question the way he's being asked. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what really goes on in these medical malpractice trials, in these accident trials, in these wrongful death trials here in New York. You know, I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you still have not brought a lawsuit because you still have questions that need to be answered, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.